name is Emily Calvin, and I am a Florida licensed attorney practicing family law with a specialization in domestic and intimate partner violence cases. This is part 2 of a multi-part video series related to stay-at-home parents and their rights in family court. Today, I will be talking about relocation as it relates to custody. When we're talking about relocating with children, there are a couple considerations, some of which related to whether or not it is prohibited by statute, and the other considerations are related to jurisdiction, which I will go into detail in a bit. Florida does have a relocation statute, which does prohibit relocating with the minor children in certain circumstances. The relocation statute only applies after a court case that involves custody is filed or a court order is entered related to custody. Once a court case is filed involving custody, either parent is prohibited from relocating with the children without either a court order or the other parent's written consent. Florida statutes defines a relocation as anything 60 days or longer and a distance of over 50 miles. And that is a straight line distance, A to B, or as the crow flies, which is a little different than Google Maps directions distance. If a court case has been filed and you do not have the other parent's written consent to relocate with the minor children, you will have to file what's called a supplemental petition to permit relocation with minor child in the case that has already been filed involving custody. Technically, if you relocate prior to that supplemental petition being filed and granted, the court should deny the relocation. The supplemental petition to relocate is very particular and has very specific requirements by statute, so it is important to consult with an attorney before filing one. There is a pro se Supreme Court approved form for the supplemental petition for relocation on the Florida Supreme Court Forms website for family law. The other consideration that comes up regarding relocation is jurisdiction. And that is going to apply regardless of whether the relocation statute does or doesn't apply to you yet. Because there is a situation where you may be able to relocate without violating the relocation statute, but if a case is filed soon enough after you leave with the child, there is a chance the Florida court can require you to return the child to the court's jurisdiction or the state of Florida based on jurisdictional considerations. When we're talking about jurisdiction, generally you have what's called personal jurisdiction, which is the court's authority over the parties, and subject matter jurisdiction, which is the court's authority over different subject matters. And when we're talking about custody, we're talking about subject matter jurisdiction over custody. And in order for Florida to have subject matter jurisdiction over custody, Florida has to be the child's home state, which is defined as the child being in the state of Florida for 6 months, anytime in the last 12 months. So what that means is even if you leave the state with the child before any court case is filed, and the child is no longer residing in the state of Florida, Florida could still be determined the child's home state if it would have been the child's home state. In other words, the child had lived there for the last 6 months, anytime within the last year. So that means that you have to be out of the state for over 6 months before Florida would lose that home state jurisdiction. When we're talking about custody, there are a few different types of subject matter jurisdiction. The main one, which is the one I was just talking about, is initial and continuing jurisdiction. And that is when no other state has exercised jurisdiction over custody matters and Florida is the child's home state. If Florida exercises initial jurisdiction over custody, that is what's called continuing, which means it does not end or lose that jurisdiction unless and until another state judge talks to Florida and Florida agrees to relinquish or give jurisdiction to the other state based on a lot of other considerations that involve Florida law and the other states' laws. There's also what's called emergency temporary jurisdiction, which means that maybe the child has not been in Florida for 6 months. Florida is not the child's home state, but the child is physically located in Florida, and for some emergency reason, Florida is required to exercise jurisdiction to protect the child. In that case, Florida would take jurisdiction for just the time it is required to protect the child, and something else would have to be filed in order for Florida to take more permanent jurisdiction based on a conversation it would have to have with the state that had originally exercised initial and continuing jurisdiction. There is also jurisdiction to modify and enforce an order, and that is going to depend on what state has exercised initial jurisdiction and whether or not that state is still going to be considered the child's home state and where the child is located currently, and a lot more other details about sort of whether the court has the authority to modify an out-of-state or foreign judgment. Just to be clear, when the court orders in Florida the return of the child to the court's jurisdiction, technically it only has the authority to order to the return of the child or children. You actually, as the parent, do not have to return, but usually what that means is the custodial parent who has left the state with the child, of course, returns with that child when the child is ordered to return. There are some criminal considerations as far as relocating with children, depending on whether there are custody orders in place or not, and whether there has been any notification to law enforcement in the place where you have left and the place you are going. I'm not going to get into detail with all of that. I am not a criminal defense attorney. I would suggest that you consult with one if you are thinking of making a major decision like relocating with the children without the other parent's consent or court order. Also something called the Hague Convention that is related to taking children out of the country, and that is much more complicated and not something I'm going to go into detail today about, but that is something to also look into if you are thinking of relocating internationally. Of course, before you make any decisions or do any actual relocating, I always suggest that you consult with an attorney in your area so that they can assess your specific situation and let you know kind of what your options are and what the consequences of each potential choice you make could be. Thank you for listening, and please stay tuned for more on this subject as well as many others.